you also should have their biography panels. You get back here for the camera. You should also have their biography panels printed in front of you in case you want to learn a little bit more about their background and history. We do have some Golden Gate graduates as well. So without further ado, I'm going to let Greg take it over for the civil litigation panel.
All right, everyone, welcome. I'm Greg, and this is the civil litigation panel that we've all been looking forward to. We're going to get started just by having each of the speakers introduce themselves, where they work, what type of law they work in, as well as what a typical work week looks like for them in their type of law, as well as their favorite thing to do that's non-law related. So that's a lot to memorize, but you got it right here, so you'll be good. Why don't you get us started?
Okay, sure. Hi, my name is Meghan Strong. I am a Deputy Attorney General in the Government Law section of the Office of the Attorney General. I practice civil litigation on behalf of the Attorney General, mostly representing the Attorney General and other government entities in civil lawsuits. A typical work week for me, usually it's a lot of motion writing, some court appearances. I have a court hearing on Thursday this week, but the vast majority of my practice is really research and writing focused. My favorite thing non-law related to do, I'm a really big baker. If we had a Great British Bake Off in America, that would be my goal.
Good afternoon. I'm Lubna Jahangiri. I'm the founder and managing attorney at Jahangiri Law Group, located in San Ramon. I practice business and real estate law, mostly breach of contract and partnership disagreements. 80% of our work involves litigation and trial work, 20% transaction work. A typical work week for me, because I am responsible for bringing in business for the firm. My typical week involves networking, supervising junior attorneys, mentoring them, also doing some original brief writing if the attorneys are on vacation or they're too busy to handle that. And then if it's trial, then I'm in trial for weeks at a time. My law and motion practice mostly is handled by associate attorneys. Favorite thing to do that is not related to law is reading. I love reading historical fiction, and I love playing mahjong solitaire online.
Good afternoon, Michael Osborne. I've always practiced in the San Francisco Bay Area in San Francisco. I work for a firm now that's headquartered out of Texas, so I opened their San Francisco office, so it's myself and another attorney here in the Bay Area. And I practice almost exclusively in the defense, personal injury, wrongful death litigation. There's a little bit of commercial litigation. That's been the primary focus in the last 10 years or so. Over 40 years since I passed the bar exam. It's been criminal prosecution for a number of years, and then I went into civil. Civil has all been on the defense side, but a lot of commercial litigation also. The typical work week, right now I'm doing a tremendous amount of traveling again, and so I'm traveling pretty much 2 or 3 weeks out of the month. It's all for depositions and court appearances, client meetings, and witness meetings. Because there's only 2 of us out here, we pretty much share the work as far as motion writing, court appearances, that kind of thing. And then non-work related, basically spending time with family, especially when I'm traveling so much. So when I get home, then I got to get caught up on all the things that are going on with everybody in the local family.
And as you can all see, we don't have a couple of our speakers here. One of them might just be running late. The other one just said they couldn't make it due to some unmovable event. So, but we're going to carry on with our 3 strong speakers here, and Greg's going to ask them some more pointed questions.
Absolutely, absolutely. Yeah, this one is for you, Megan. And you work in governmental law, as you said. What makes governmental law unique, and maybe a case that illustrates this that you've worked on?
Sure. So I should say I practiced at private law firms for about 5 years before moving to government law. I've only been working for the Attorney General for about I think about 6 months. So I have a lot to compare and contrast. But I would say that, funnily enough, a lot of, at least in the section that I work in, there's a lot of commonality in terms of the skills that you would need. I think the work I did in private practice has lent itself really well to government practice. The main difference is that your clients are government entities, and that does tend to lead to some more government-focused issues. So I do a lot more constitutional law than I did in the private sector. I deal with things like the Dormant Commerce Clause that doesn't tend to come up quite as much in the private sector. For example, I have a case that deals with defending one of California's common gun laws that the plaintiffs are bringing a Dormant Commerce Clause challenge to it, alleging that it treats out-of-state entities differently than in-state entities as it pertains to the sale of ammunition. And so you just tend to encounter certain issues that by nature are unlikely to come up in the private practice, but come up quite frequently in the government context, and they're really fun and interesting to work on.
It's not just con law class that those things are important for your career as well. Okay, Lubna, can I call you Lubna? What was the biggest obstacle in starting your own firm? Told us you're on your own firm. What motivated you to start your own firm?
And IT's told me if you guys can all move the mics closer to you, I think this sounds better. Thank you.
Yeah, so I was not the typical law student. This was my second career. I was in the field of mental health, and I had been working for nonprofits in various capacities for 10 years before I decided to go back to school and study law. So when I graduated, I was 39, and I had life experience behind me. I had started a women's shelter in Fremont, and I had started some other programs, and so I really wanted to start my own law firm. But the biggest obstacle was fear, right out of law school, and just don't know if you'll end up hurting someone or harming their case. But I read a book, and I don't think it's available anymore, Solo Practice, Flying Solo. And I read that book. That gave me a lot of confidence. I was working for a law firm. I was there for maybe 6 months, and I just decided to take the plunge and start my own solo practice. But the advantage I had was that my husband was working at the time. He was a medical resident, not making a lot of money, but enough for us to get by. I had 2 young children, so that was another motivation for me not to work for a law firm long hours, and I started very slowly. So just taking maybe one case at a time, transactions, and then moved on to litigation. So that's how it started, my firm. And then when in 2012 my youngest son went off for college, that's when I started focusing on my career full time. And since then I formed a small law firm. We are 4 attorneys. One of our law clerks is soon to be an attorney, so it will be a 5-attorney law firm. And it's just been a great, great experience.
Absolutely. Michael,
Yes,
you
sir.
told us you do some work in fraternity, sorority related law and related cases. What's been your most notable case that comes to mind?
So I'm sure people are wondering what the heck. A lot, about 10 years ago. I practiced for a long time in products liability, and what I saw in products liability is that the national product manufacturers have basically dedicated counsel nationwide that try to develop appellate case law. They try to develop common discovery issues, common experts. And so I handled a few fraternity cases. These are personal injury cases defending the national nonprofit organizations. And what I did about 10, 12 years ago is I recognized that the national fraternities needed the same kind of representation nationwide, because the fraternity being sued in Missouri or in Mississippi is the same fraternity being sued in California. So I put together a proposal where they tell you to be careful what you ask for, and the client said that was a great idea. And so for the last 10 years, I've been defending national fraternities and sororities across the country. And it's always the national nonprofit organizations. If something bad happens on a college campus, and somebody gets hurt, these are all tragic, horrible cases. Everybody gets sued, including the students that were involved, including the local housing corporation, and then they also sue the international or the national fraternity, because that's the target. Again, that's the product manufacturer. So the most notable in looking at what we set out to do in this mission I had was to develop things across the country, experts, telling people if you're going to go into a courtroom and tell a jury what a fraternity is, you need an expert to try to explain that. And so we developed experts. And then the most notable one is in appellate law. I had the honor of arguing in front of the California Court of Appeals. So I won a summary judgment in Los Angeles. The plaintiff's attorney appealed it, and we went up on appeal, so it was argued. So I argued that before the California Court of Appeal. It was a case of first impression. California had never addressed the issue. Is does a national nonprofit fraternal organization owe a duty to somebody on a campus in a personal injury kind of situation? Because as you know from your torts class, the first thing you have to prove in negligence is a duty. And so that was the first case in California that went out on appeal, and argued it, and it was affirmed in published opinion. And now I have the pleasure of citing to my own opinion across the country in other states, and there are other state Supreme Courts and appellate courts that have relied on the California court. So again, that was just a notable thing that we had set out to do, was to try to develop the case law so it's more consistent across the country. And some of it involves sororities. I'll tell you that the men get in trouble a lot more than the women. They got that figured out long ago, that the women just behave a little differently. Their houses are nicer and cleaner. And so there's not much sorority litigation, but I've had a couple bad situations, mostly on the hazing side. But it's mostly the guys that keep us busy.
So, Michael, really quick, you mentioned that, something bad might happen, usually someone gets hurt. Are you dealing with sexual assault cases on campus too, or is it mostly physical assaults of people get in a fight or something?
It's all.
Okay.
I tell you, 99% of the cases involve alcohol. Somewhere in the situation, alcohol's involved.
Yeah.
But there are sexual assault cases, there are wrongful death hazing cases. And you know what, because we know the cases so well, we recognize that someday that case is going to settle, and you have a grieving mom and dad and a grieving family, or an injured person. And our goal is to get them to the point where they can settle it, hopefully sooner rather than later.
Yeah.
And to make everybody feel like they were able to walk away and
Put
fight
it
for
behind
justice.
Yeah, I mean, not forever, obviously, but
Right.
put that specific part of the litigation behind
For
it.
sure.
Yeah, well, yeah, that's a great goals you have with that.
And I just would mention again to the law students who are here, as you develop your practice, always be creative, always be innovative. And that's kind of what I did, was saying, I saw, wait a minute, there's a group of clients out there that have no commonality, but they're facing the same issues. And that's what I think is something to remember when you get out of law school.
So, if you're aware that it's mostly alcohol that kind of fills these cases, is there a way to maybe, I guess, how do you handle the fact that it's alcohol? I mean, everybody knows it's alcohol that fuels a lot of these cases. How do you handle the fact that there's still a lot of drinking on fraternity and sorority houses and stuff like that?
And that's another issue that's interesting in these cases. There are a lot of societal issues. And so that's just a really compelling question about the presence of alcohol in today's society. What I see now as a parent and also in these lawsuits is, the young people are drinking in middle school, they drink in high school, and then they're drinking like crazy in college. And so alcohol is really, really difficult. Some fraternities have attempted to go what they call alcohol-free, so there will be no alcohol is allowed in the house. Students find a way around that. They find a way what do you mean by the house? Does that mean the backyard? Or does that mean the house? You'll have 21-year-olds that are living in the house. They say, well, wait a minute, it's legal for me to have alcohol. I want alcohol in my fridge. So, it swings both ways, back and forth. The fraternities, a number of them have gone alcohol-free. Some of them use it as an incentive, like if you get to a certain GPA and you do all the right risk management, then we're going to let you have alcohol. The sad thing is that in the fraternities that are called dry, it's still the same number of people that are drinking. And it would be nice to put an end to that, but
you had the opportunity to represent Divine Nine fraternities or sororities?
Yes, I've had the honor of doing that. So we rented 3 or 4 of them here in California, and 1 in Florida. And those fraternities and sororities, it gives me goosebumps. I mean, represent an organization where it was created for women before the women had the right to vote. And I've never watched them in Indiana where they had their 100-year convention. And so that's just compelling, the kind of heritage that they give to the students to do better in school and become better people.
Absolutely. All right. Switching gears a little bit here, wondering, you briefly touched on this, but what piece of advice would you give law students that you wish you would have known coming out of law school?
Start with me?
Well, if you want, but
Oh, no,
yeah.
I think there's this.
Yeah, well,
No,
you started giving advice, so
Yeah,
we
you go ahead.
can come back this way. You start, and then we'll come back this way.
Well, I think one thing we don't really talk too much in law school is like, it's a business. I mean, it is a profession, it's a great profession, and it's why I'm not retired, because I love it, and I love what I do, and it's a challenge every day. And we've talked about every day you learn something new. You never stop learning. But the reality is, when you, particularly now, and it wasn't so much 40 years ago when I started law school and got out of law school, but it's really a business. And so when you get into your law firm or whatever job you have, recognize that somebody in that firm is trying to make money, they're trying to develop a practice, they're trying to be successful. So when you start out, realize that your supervising attorney or your boss, whatever you want to call that person, is your client. Your supervisor has clients. You as a new person probably don't have clients, but your supervisor is your client. So treat your supervisor like your client. You know, when there's a project due, it'd be great if you got into that person early. We only talked about work-life balance at some point. but again, it's just learning that we're in a service industry, we're providing a service. And if you're providing a great service to your supervisor, that supervisor is going to recognize, wow, this person can provide the same great service to a client. And then you meet clients at conferences and never stop talking and meeting people, because the person you meet today might be general counsel of a large corporation 10 years from now. And if you're going to practice for 45 years like me, you just keep those relationships going, because you get a phone call or an email from somebody that said, I saw you, I met you in law school, and I'm looking for a different attorney. And those are great opportunities. So remember, it's a business, enjoy it, and be successful. If it makes you happy, you also got to be happy.
Yeah, I want to also carry on what Mike was just saying. Never ignore the power of networking. And I was not aware of networking or the value of it when I was in law school. And being an introvert, it was really difficult. Okay, I want to do what? Enter a room full of strangers and go and talk to them. So I started reading books. You know, there are plenty of books on networking, and that was the foundation stone that led to me developing my business. And it's just invaluable, even if you don't have a business and you don't start out right out of law school as a practicing attorney on your own, and I don't recommend that. I took the difficult path. I recommend working at a law firm for years, for a few years, and then moving out on your own if that's what you would like to do. But even if you start at a law firm at the lowest rung, do not ignore the power of networking and rainmaking. You can still bring in your clients or referrals. You know, treat your boss as a client. Refer your friends, family, people you network with, refer them to your firm, and you will become indispensable if you're bringing in business for your law firm, no matter how big, because it is a business. The second piece of advice I have is, if you can intern for a judge, federal or state, because you will, you know, when you put that on your resume, and when I look at resumes, and that's another question, but I look at experience more And then if I see, someone has worked for a judge, you have knowledge of how judges think. You can get into a judge's mind, and when you're writing a brief, that would be invaluable. I used to write, brief, it starts with an introduction, then there's procedural facts, legal analysis, and conclusion. And I used to write for all the foregoing reasons, this motion should be granted, and that's it. And a judge once told me, that is the first section I read. So, now my conclusions, they have a summary, they have a concise summary of all my points, and so do the introduction. So just things like that, that would be invaluable.
I think the best advice that I've ever received, and that I think I have really tried to live by as a young and up-and-coming lawyer, is you're an advocate for others, but you're also an advocate for yourself, and nobody is going to advocate for you in your career as much as you can for yourself. And so ask for opportunities. If you see, a deposition coming up, ask to take the deposition. If they say, you're too junior, we'll ask to sit in on the deposition. If you're going to trial, ask that you be given some opportunity to stand up in court, whether that's to argue a motion or to take a witness. And don't hold yourself back in the opportunities you ask for simply because you're a certain year or you think you might not be ready, things like that. You'd be surprised. When you get out of law school, you're ready for a lot more than you might think you are, and especially if you have good mentors who will support you in, taking your first deposition, taking your first witness, things like that. You don't need to hold yourself back just because you're a certain year. And I think, particularly if you end up I practiced at 2 very large law firms for the first several years of my career, and I think there can be a mindset of there's a certain level of experience or number of years you should have before you do certain things. And I didn't play by those rules. I was standing up in court when I was a first-year associate, and it was because I did those things early that I was able to move forward in my career at a different pace than I think other people did. And so ask for those opportunities, and even if somebody says no, keep asking. Somebody's going to remember the next time they have a deposition, so-and-so said they want to do that. And that's going to be the best way for you to advance in your career, and also for you to learn. The best way to learn a lot of the skills we do in litigation is by doing. And the only way that you can learn to do them and do them better is by doing them repeatedly. So advocate for yourself. The flip side of that is to advocate for yourself. We're going to talk about work-life balance more later, but to advocate for yourself in the things you need, in balancing your life too. There are any number of ways that you can advocate for yourself, both to advance in your career, but also to get your career to be what you need it to be. And there's nothing more important than speaking up for yourself, I think, especially in this profession.
Absolutely. And then what steps can students take now to make them attractive candidates at their firms when they graduate? Megan, you were just mentioning you started at 2 big firms. Maybe you could start and say how the process went for you.
Yeah, I think some of the things, if you're looking at a big law firm, some of the things law firms of that size and nature look for are working on a journal, if you have the opportunity to work on a journal. I will admit I hated working for my journal, but you know what, it taught me how to blue book really well. It made me a better writer, and so although I didn't love it when I was in law school, as a lawyer now, I can see why it was an important thing to do in law school. Other things that I think are attractive to law firms in particular, just really strong writing skills. Think really carefully about the writing sample that you submit. I think especially for new lawyers, because we don't have a lot to evaluate students on. People actually do read your writing samples, at least I did when I was interviewing people. And so, if you're taking something that you wrote a couple of months ago, even a year ago, take a look at it. Is it still consistent with your writing style? Polish it up, things like that. And the other thing I will say is having a real interest in things. When you're a new lawyer, you don't have necessarily experience in a field, but you can still have a concerted interest in the field. So if you're interviewing for a job that you might come across a certain field of law, being up to date on what the current issues are in that field can really set you apart in an interview, for example. So even if you don't have experience or background in something, being able to show concerted interest will really set you apart.
So I can speak for small law firms up to 10 attorneys, I should say. And when I'm interviewing or looking at resumes, yes, grades matter, law school rankings matter, the Kelly writing and research certificates matter. But because in a small law firm, the new associates, even if they have zero practical experience as a lawyer, they have to hit the ground running because we need all the resources that we can muster. So what it boils down to is your practical experience. So if you, like I said before, if you've interned with a judge or with a law firm, and what I look for is writing. Writing, if you have experience in law in motion, which means that you've written briefs and you've opposed motions, and that is the bulk of litigation. It's writing briefs. And then the other thing I look for is experience in discovery. So if you have paralegal experience before you join law school, that's amazing. Experience in discovery and law in motion work, that's what I'm looking for.
Yeah, I think I would agree that, writing skills, we do a lot of writing as lawyers. And when I'm looking for an attorney, you may use a number of resumes or cover letters or emails that you get that are full of grammatical mistakes or full of spelling mistakes and don't focus the issue, like what kind of law they're looking for. So you just really need attention to detail. Ask yourself, before I write it, what am I trying to convey? Who is my audience? I think that's the biggest, most important question. Like you said, you'll write differently when you want a judge to read it, or you're going to write differently than when it's going to go as a memo to your supervisor. So again, attention to detail, and just always trying to make sure that your work product looks as good as it possibly can. Take that few extra moments to go through it, look it over, and make sure you're conveying the message that you want to convey.
It's all very good advice. And speaking of advice, who was your mentor as you began your career? Or from whom did you learn the most about civil litigation? If we want, we can keep snaking around. Let's start with
When I started out, I spent 8 years as a prosecutor. So I was 3 years in El Dorado County up in South Lake Tahoe. And then I came to San Francisco, and I was in 5 years with San Francisco DA's office. And then after I left the DA's office, I went into a civil firm. So I went into a civil firm. It was small. It was like 3 lawyers. When I started as a prosecutor right out of law school, it was in South Lake Tahoe. Again, there were 4 other prosecutors. So one of the really great things is starting into a small group, because they need you. They're going to give you experience. They're going to put you to work, and you're going to hit the ground running. Eventually, I went into a couple of big firms, big law, and I saw brand new lawyers coming in, and they're basically sitting behind a desk looking at documents or discovery, or they write a memo that's going to be rewritten by 5 lawyers above them. So I think it's really great if you can start small. Your mentor is going to be someone that will say, here's the file, there's the courtroom, let me know how it goes. Or like when I went from criminal to civil, I'd never taken a deposition before for 8 years, because we didn't do those in criminal cases back then. And then I hit a civil law firm, and the boss said, here's a deposition, read the file, and I'm trying to figure out what a deposition was. But being in a small firm really, really helps, and I think that gets you the feeling like, what do you like, what are you good at? And it just helps you, I think, get through it a lot faster.
When I started out, I didn't have much experience, and I didn't have a network. I had no mentors, so I would randomly call attorneys from the yellow pages, the hard yellow pages. Yes, those existed those days. And I would just say, you know, I'm a new attorney, and this is an issue I'm having under my duty of competency. I felt I had to do that, and they would give me advice. I was just so surprised and impressed that attorneys who didn't know me from Adam would give me time, invite me to their office, look at my documents, and then mentor me. And then I worked for a firm, Riddell and Webb in Walnut Creek, for about 6 months. And it was Sabina Webb, the partner. She was only a few years senior than me. And she doesn't even know I'm saying this about her today. But she is the one who really made me a litigator. It was a family law firm. The first declaration for a client I drafted for her had like 3 paragraphs. It's short, 3 short paragraphs. And she looked at it and she said, what is this? You know, where is the rest of, take it back and write more. So that's how I learned to write my motions and litigate. And then again, I would reiterate, if you can, don't go right away solo. I don't think there's still, I think California still allows that. There's no residency requirement, but don't do what I did, because it's really difficult. Join a law firm, learn as much as you can from them, and then if you want, you can start your own practice.
So picking up on the tail end of what was just said, the years I spent early in my practice at big law firms were extremely important to allowing me to do what I do today, including because of the plethora of mentors and mentorship opportunities that were available to me. When you work in a big law firm, you're surrounded by so many different lawyers, and all of them are potential mentors. And so when you are a new lawyer, you should talk to everyone and ask them, hey, why did you do this way? Can you talk to me about this? I'm interested in doing X, Y, Z. Literally anyone can be your mentor if you just talk to them, and the vast majority of lawyers really like to talk about what they do. You just need to find an opportunity to sit down and talk with them. I was really lucky when I started out, literally my first day as a first-year associate at a law firm. I got put on a case with a very senior associate who took mentorship very seriously, and she taught me everything that I know. Whenever we had something happening in a case that was new to me, she would explain to me what it was, or how we were going to do it. She was very generous with her time, and I was very lucky to be able to then follow her to another law firm and work for her when she became a partner, and our journeys stayed together for quite a long time. And that happened very organically, but that's not always the case for a lot of people. And so I would say, don't feel discouraged if when you start practicing, there's not one person who is like that for you. Sometimes, you just need to learn different lessons from different people, and that's okay too. If you are, I would say the main thing is if you're in a courtroom or somewhere where you see someone and you're like, wow, what they're doing is really cool, I'm interested in that, talk to them. Nobody's ever going to be mad that you asked them about their job. They might be short on time, but you're never going to get in trouble for it. And so just take every opportunity you can to learn from them.
There you go. Absolutely. And then everyone's favorite question, how do you handle work-life balance?
You want me to start with this one?
Yeah, sure.
Okay. Like I said, I worked for big law firms. They demand a lot from you. There's a reason they pay you so much. They expect you to work very long hours. It's difficult, and I spent a lot of nights and weekends and holidays working early in my career, and I won't lie that that's hard. And it was also one of the reasons why I chose to move from private practice into government work. I feel that I have a better work-life balance now than I did at private practice. At the same time, I think I actually had a relatively good work-life balance for a law firm associate for the main reason that particularly once I got through my first couple of years, I was very intentional about setting boundaries and communicating with people about, if there was something, I had a family event I needed to go to, I wasn't going to be available, telling people that. So that they would be prepared. This person who I was talking about who was a mentor of mine, we worked on a lot of cases together, and we used to trade off, like, you're going to be available this weekend because I have a thing, I'll be available next weekend because you have a thing, and creating partnerships with people you work with so that you can help each other get the work-life balance you need, I think is one of the most effective ways to balance it, especially in an environment like a law firm where you're necessarily going to be working more than a 9-to-5 job. I think also deciding what your own priorities are is really important. Not everyone is willing to give up what they have to give up in their personal lives to work at a big law firm, and that's completely fine. You can still get really valuable experience in other settings. And so I think just having really serious conversation with yourself about where you want your priorities to be is really important, and that can change over the course of your career too. It might be that you have, a period of time when you have young children, and so you're just not going to work as much. And that's great. You just need to be frank with yourself about where your priorities are going to be and what sorts of boundaries you need at different times of your life.
As a litigator, the work-life balance weighs very heavily in favor of work. There's very little time for personal life. When you're in trials are brutal. I just finished a trial in February, started in January, and I was sleeping 3 to 4 hours per night for almost a month and a half, and that's just brutal. And then after that, the trial was over, it was on to the next thing, and I didn't take a break. In litigation, it's very few part-time positions that are available in law. And some of my family members are doctors. My husband is a doctor, my son is a doctor, and they have better work-life balances. Medical school is definitely tougher than law school for 4 years, but their lives are much better than those of a litigator. So just putting it out there.
You're all screwed.
I think they're all already in law school. I don't think you can sell them on med school now.
Michael, any optimism on the?
So I always call it a work-work balance. But the reality is, what you want to do in your life and your family or your friends or your hobbies, those are so important to you. And if you're not happy, if you're not a happy person with your life, then you're not going to be a good lawyer. So I want people around me that are happy and productive. And so I think it starts with communication. You just really need to communicate with your team or your supervisors and your fellow attorneys. Like, what is the expectations? What are the expectations? What are the requirements? If one of my associates calls me up and says, "Oh, I've got something going on," it's like, fine, do it. And at the same time, you recognize you're providing a service, so you've got to deliver your product. At some point, you can't keep calling up and asking for another 5 days. Just like you can't call your client and say, I'll get to it when I get to it. So you have to kind of take control of that and be responsible to communicate, to share that information, to understand what the expectations are. One thing I've really liked about litigation is if you're on top of it, if your team is on top of it, there's no real surprises. I mean, there are occasional last-minute crises, but pretty much you can kind of plan in your month. You know when your motions are due, you know what's coming up, and if you stay on top of it and your team stays on top of it and your support staff, it's not like the transactional lawyers that find out there's a closing in Hong Kong tomorrow and you've already lost 12 hours and the client expects it on their desk at 3 o'clock in the morning or something like that. So I think that there can be some benefits to litigation. It's exciting, and you just take that excitement to the rest of your life, as far as sharing with your family and being there for your family. But of course, there was trials where the family's on vacation and I'm still in a hotel room and in a courtroom. But when I got out, then I took time off. I mean, you gotta balance it for yourself, because if you burn out, then that's not good for your firm, it's not good for you, for sure.
Last couple of questions, we'll go down this way. What is a character trait that most, if not all, outstanding civil litigators possess?
I think being flexible and nimble is really important. I have a mentor who used to always say, be nimble, be nimble. Although I agree with Mike that there aren't a whole lot of surprises in terms of scheduling, what happens, things like that. People can say crazy stuff in the courtroom all of a sudden, and sometimes that can be to your real advantage. And it's easy, especially when you've worked on a case for a really long time, to sort of get blinders on about this is how this case is going to proceed, this is how I see it, this is how the other side sees it, and that's how it's going to play out. But sometimes it doesn't go that way, and sometimes that's the best time when you can take advantage of something and turn it for your client's gain. And so being flexible and being able to take advantage of those moments and sort of not taking a single-minded approach to a case, but really thinking about all the different variables and things like that are what's going to make you the better litigator. And ultimately, in a lot of, especially in civil litigation, often some of these issues really do come down to who's the better litigator, and I think it can often come down to who's more flexible, who's taking better advantage of what's actually happening on the ground, especially, I would say, in trial.
Yeah, that's for sure. And then what I would also add that issue spotting, and that's what law schools are great at, teach you the issue spot, and also preparing for the bar exam. So use that skill, because it's all about issue spotting, attention to details.
Yeah, again, I agree that it's flexibility and attention to detail and being creative. I mean, I think we see a lot of lawyers that just do it the way they do it because that's the way it's always done. And those are the lawyers you can just mess with. You can mess with them because you can do something different. There's no reason why you've got in a complaint, for example, you see plaintiffs' lawyers in a really bad, horrific earth injury case. They start out in a complaint with the parties, the venue, the jurisdiction, and you're like on page 12 before you get to what happened. So I had this plaintiff's lawyer in a horrific hazing case where his first paragraph was a photograph of the young man who passed away. And the second paragraph was some of the bad facts. Why is that? First of all, he hands that to the media because the reporter doesn't go to page 12 to read what's going on. The reporter sees page 1. And I thought he was brilliant because nothing in the code book should say that you have to start the first paragraph with jurisdiction. Somewhere in that complaint, you've got to have jurisdiction and venue. But in the first paragraph, do what you want to do. And it was a tremendous moment. And there's a bunch of copycats now around the country that are copying his complaints. But and from the defense side, it's again being innovative. He started depositions. So many lawyers started deposition. Like, let me tell you what a deposition is. Do you know the difference between an estimate and a guess, and this. And you can start a deposition where you just go right at them with a question and catch them off guard. Or if your strategy is that you want them to be relaxed and be comfortable and be happy and all of a sudden give you great evidence, then you can start a deposition a different way, which is to start out as their best friend and conversational and get them quiet and relaxed before you start getting the tough questions. So flexibility and just really being creative and thinking to yourself, like, how can I do this differently that's going to be better for me and for my client?
Sounds like there's a lot of psychology behind all those.
There is. There's a lot of psychology.
Okay. Well, with that, first of all, can we give a hand for our speakers? And I think we have some questions from the audience. If people have any questions for any of the speakers generally or individually. Yep, there.
Thank you for being here again. With regards to the writing, as I was with public defender for almost 2 years, and I can see that a lot of places, including some firms, public defenders, they have brief banks, so it's not an ability. I didn't get to work on my writing the way I wanted to, because you have to do something, and I wanted to tell them, hey, I want to know how to learn it. I want to know how to write it from the beginning. They're like, no, this is not the place because there's a brief bank. So how can young, as first year associates that we're gonna be, how can we get better at the writing besides doing the writing, but like tools, like here do this, here there's like, I'm thinking attending as many conferences as I can to read, go with Mr. Gardner, hey, get his number, call him up, I don't know, things like that.
I will respond to that because I have this book in our office, Elements of Style,
Yes.
shrunk and white,
Yeah.
and I make that mandatory for all associates to read that, and that's on firm time. And so, just read, attend CLEs, Mr. Gardner's CLEs, sometimes I play his videos during our staff meetings, take CLE courses, because you can never stop being a good writer. Like Mike said, you're always learning. So just keep honing in the skill, because it's a skill, and that's the most important skill in litigation. So.
I would also say there's a lot of materials on how to write, which are really great, like Brian Gardner, like Elements of Style. Those are all really helpful to sort of break things down for you so you understand the how and the why of writing. But I also think reading examples of really excellent writing is really helpful too. I know I've learned a lot from reading the briefs of people senior to me who are writing them, but also just pull briefs from Supreme Court. You don't have to pay attention to who's writing them, but you should, if you go to sort of like the highest levels of our court system, you're usually going to find really excellent examples of writing. And the more of those you read, the more you'll be able to observe the different techniques that are being used, things like that. And I've learned a lot, and I think I've improved my writing a lot that way as well.
Any questions?
I just want to add something to that, and that's what I experienced personally, is just read, in general, read books. They don't have to do anything with the law, but sometimes I'm reading fiction, and I'm saying, it's stated so well. And then I just memorize the way it's written, because it's just so clear, it's so persuasive. So, yeah, just keep on the lookout.
Any other questions?
Yeah.
Hi, yes, first of all, thank you for being here today. I have a question that I think is probably very outside the scope of what you had planned to speak about today, but I think we all agree that there are always evolving tools that any law office will use over time. And so I'm just curious about your use, if at all, in your everyday practice of generative AI as a tool. If you use it at all and how you do so, given all that we hear about it in connection with law practice in general.
I can speak to that. I don't know if you both have experiences as well. I think that a lot of different parts of the profession are working on incorporating generative AI into various aspects of our work. The places I've seen it used most, I think, are in two contexts. You may have seen on Lexis, and I think they're starting to build it into Westlaw. I've seen people using those tools. I think those tools are helpful. They always have to be checked. But I've seen people use generative AI in their research to great effect, particularly to draw connections between different types of law and cases that might not be produced in a normal search, but the AI might draw some connection. I found that to be interesting. This isn't generative AI, but I've also seen machine learning, and I think they are starting to incorporate generative AI into discovery and document review and document analysis, and I've seen that used to great effect as well, both for reviewing documents, but also analyzing and finding things within documents that maybe aren't text-based but are image-based, things like that. So I think it is happening. I think the legal profession can sometimes be slow to adopt new technology, and so I think depending on where you are, you might find more or less of it being adopted, but certainly I've seen a lot of people who are working on bringing it into the profession and finding and building new ways for all of us to use it. And I think that's great. I think there are also ways we have to be careful about it and make sure, we've all heard about the people who are writing briefs with fake cases, things like that, and so we always need to make sure we're doing it in a responsible enough way. But it's a fascinating new frontier, I think, that lawyers are working on.
either of you using AI at all?
No, but it's really interesting. I did speak with a lawyer that I work with in Philadelphia, and he had told me that he just recently got an expert's report in a personal injury case, and then he used AI for the development cross-examination of the expert. He said 80% of it was brilliant and 20% of it was garbage. And now you got to decide what the percentages are for you. But that really opened my eyes. So like, well, yeah, maybe that would be interesting to try that, because it doesn't hurt to try.
Yeah.
And save time.
Yeah.
But we have to, lawyers have ethical duties, and so I think when we're
Right.
using generative AI to help us create work product, we always have to make sure we're abiding by our ethical duties as well.
Should be good?
Yeah.
Yeah.
Good.
Thank you again to all of our speakers.
Thank you so much.
That was amazing information, a lot of information, a lot of helpful information for all of you. And for our students, thank you for being here. If you have any questions for any of our speakers afterwards, I can provide you with their contact information. But with that, thank you for being here, especially on Saturday and all that.
Thank you.
Yeah.
Thank you.
Thanks for
Great job.
Yeah.
Thank you so much.